good morning, and thank you for the opportunity to be here. My slides are in English. I'm sorry I wasn't able to get them translated, but we'll talk through the slides. First of all, let me say congratulations. I saw the video of Conchita Wurst over the weekend, and you must be very proud as Austrians. Absolutely. And it's so fitting that you won that award with Conchita Wurst this weekend, given her message of peace and inclusion, which is a very fitting start, I think, to our conference, your conference today. Thank you again for the opportunity to be back here. It's a great privilege for me and my colleague Pooran, Brendon Pooran. Austria not only has Conchita Wurst, but has many advocates for inclusion. And colleagues and friends of mine, Bernhard Schmidt, who's here, Walter Eigner, who was the president of our international federation, Inclusion International from Austria, and was the leader in changing the name to Inclusion. Speaks well, I think, of the commitments and values in Austria to advance our agenda of inclusion. So I'm also pleased to be sharing time today with Mats Jespersen, who's going to speak about the experience in Sweden, which is an excellent example. What we're going to share with you from the Canadian experience is the ideas and the concepts around the right to legal capacity that we've developed in Canada and have begun to put into law, certainly in the British Columbia example, but also in other parts of the country. And so I'm going to focus on some of the core ideas. Some of you, will have seen parts of this before, but I think it's a good place to start so that we're all starting from a set of common assumptions. And then Brendon is going to reflect partly on the British Columbia experience, but also on the jurisdiction of Ontario, which is in the process of law reform to move away and consider alternatives to guardianship, which I think is very much the place and the position that you're in Austria, with the committee of the UN Convention on the Rights of Persons with Disabilities issuing its concluding observations to the Austria report in September, which pointed to many thousands of people being under guardianship in the country, and urging the government of Austria to move towards a framework of supported decision-making away from guardianship. Certainly the committee has set a very high bar in terms of its interpretation of Article 12 for supported decision-making. What I think our task as self-advocates, as advocates, as guardians, as policymakers, all of whom I know, and service providers, healthcare professionals, financial institutions, all of whom I know are represented here today in one way or another. Our challenge is to figure out how to get from here, where we are, with guardianship systems, to a framework of supported decision-making. It doesn't happen overnight. We know there's many systems to shift, many interests involved in the system as it exists. And so what Brendon and I want to do today is share very pragmatically some lessons that we've learned in the Canadian example from going from a guardianship system to a supported decision-making system. So that's the context. We're going to share the concept of supported decision-making and what the law and practice looks like in the Canadian example. Legal capacity is defined by the United Nations, and that's what we're talking about, legal capacity or the right to decide, as the power to create, modify, or extinguish legal relationships. And basically what the UN Convention says is that we have a right to legal capacity without regard or without discrimination on the basis of disability. And I think the definition is very important to hold on to, and we're going to talk in a few minutes about the usual definitions of legal capacity, the usual formula, and why we need to change it. But in these words, and again, I'm sorry that it's in English, the power to create legal relationships. It's not about having certain mental skills or mental capacities. It's about recognizing and according the power to people who have often been denied that power to make decisions in their own lives. So what kinds of decisions matter to us? And because that's what we're trying to create, is a legal framework, a policy framework, supports in the community that enable people who have often been denied this opportunity to make decisions in their own lives. We talk about three main types of decisions that we're creating a legal framework of supported decision-making to enable people to make these kinds of decisions. Medical, healthcare decisions, financial and property decisions, and decisions about our personal life, where we're going to live, who we're going to live with, who's going to give us personal care. Those are the three. We could divide all the many decisions that we make in our lives into those three main areas. And our challenge is to create a legal system that enables people who've been denied that right to make these decisions the opportunity. So that's what the task is that brings us to the table. And I guess I want to say also, by way of introduction, I bring primarily my experience is primarily in supporting people with intellectual disabilities and their advocacy associations to advance the right to legal capacity. So the kinds of models that we're developing have come primarily from that experience. Certainly they need to be adapted, and the experience of people with psychosocial disabilities brings, I think, related approaches and somewhat different models. I think we can put them all together in a shared framework, but I know that Matt Jesperson is going to bring that broader range of experience to this. I think the model that we're laying out speaks to a range of disabilities, but I just want to be clear at the beginning. That's the experience that I come from, and in the Canadian context, the models for supported decision-making have been advocated for and developed very much for people with intellectual disabilities. So the problem with the law as it exists, and I think the UN Committee has said this about a number of countries, and they'll say it about Canada when they get to our report and their concluding observations, is that it requires some professionals and courts to make a finding of incapacity and takes away the right to make our own decisions. That's what we're trying to deal with. We're trying to deal with that problem in the law, that on the basis of disability, it empowers certain professionals and the courts to make a finding that someone's incapable of making their own decisions and takes away that right. So how does the law do that? It basically, this capacity word should be under here. It basically says that makes an equation between legal capacity and mental capacity. Only if you have certain types of decision-making abilities, mental capacities, will you be accorded to have legal capacity. And I think our challenge is to break that equation apart, that our right to legal capacity does not depend on certain decision-making abilities or mental abilities or communication skills. That's the problem. And the law in my country, in your country, in many other parts of the world, basically says that if you have certain levels, types of mental and communicational capacity, that is what gives you legal capacity. The UN Convention says no, actually, that's not the case. You have your legal capacity by virtue, and your right to decide by virtue of being a human being, and your capacity to act by virtue of being an adult at age 18 or 19, or whatever age is determined in the law. So what is mental capacity, this idea of mental capacity that has been used in the law? Basically, it means that on my own, I can understand information that's relevant to that healthcare decision or that financial decision or that personal life decision. I can retain the information, I can appreciate the consequences of my decisions, and I can communicate that decision in ways that others understand. That's the test. as it shows up in many jurisdictions in Canada and in some version in other countries around the world, and some version of this you'll find in your law. The test of mental capacity to have your right to decide recognized. This is a cartoon by that great cartoonist, disability cartoonist in the UK, who goes under the name Crippen. And basically what we're dealing with is that the laws of guardianship and incapacity in my country and in other countries basically empower certain authorities, as I said earlier, professionals, the courts, to attach yet another label to people with disabilities, which we know has been the problem. And when it comes to legal capacity, the label is incapacity. The cartoon says, come along now, one more label and you're ready to face the world. Just one more label. We'll have a professional attach a label to you. And up here, this is from the Department of Dependency and Care. I think what this cartoon tells us or shares is something that people with disabilities have been saying for a very long time. What weighs us down, what stops us in the world, are the labels that get attached to us. And for those who are working to create an alternative system to guardianship, they see the label of incapacity as just one more label that's tying people with disabilities down, that's presenting barriers to them. I know you've got great advocates in this country who are guided by the UN Convention, who have contributed to that. So I'm not going to go into it in detail, but just what guides us. The UN Convention says on the rights of persons with disabilities says very clearly we have the right to make our own decisions, that governments have an obligation to provide us the support to make our own decisions, that there needs to be protection in the law against exploitation and abuse, which has been the reason and the rationale for why guardianship systems have been put into place. And I think the convention is very clear in saying governments still have a responsibility to protect people when the supports around them fail or when people are being exploited, but that it can't be done in a way that takes away the right to decide. I just want to watch my time here so that I... And the convention also says that third parties, doctors, banks, have a duty to accommodate me, to adjust their services to enable me to make my way into the community, which can include not just creating ramps into buildings, but can also include the supports that I may need to make my own decisions. So Article 12 says that we need other ways to recognize and support the right to legal capacity, not just mental capacity. And some of the other ways are that simply some of the other abilities that people have to make their own decisions is simply that they can express that they want to do something or they don't want to do something. And what the convention calls upon us to do is to make at the core of the right to legal capacity the expression of our will and preferences. I don't necessarily need to understand all the complications around exercising my will and preference into contracts and agreements, etc. If I want to do something or I don't want to do something and other people can understand that, that's enough. I don't have to have all those decision-making skills and abilities in my own head. If there are others who can understand what I want or what I don't want, that's enough on which we can build a framework of legal capacity. This is the idea which inspired our work in Canada and in British Columbia to create a different system. And that's a really important piece. So many of our systems are based on the idea that I have to have certain mental abilities to make decisions. So this is a really fundamental piece. Another ability for people who most others may not understand may not be able to understand my will and preferences. Their ability is simply the ability to be known as a person by others. This is a picture of Rebecca Bayani, who both Brendon and I know, and she has a support network around her, and she's a member of a faith community, a religious group, and this is a fellow dancer, or a woman who she dances with. Rebecca uses a chair. By all the standards in usual capacity law, she would be deemed incapable to make her own decisions, but she's known as a person by those around her, her family and friends. And that, what we're saying is that should be enough to be recognized as a full person in the law. I want to do a small experiment. Is this a light switch? Very closely here, very closely. This is the experiment. What did I just do? What did I just actually do? Any? I turned the light on, right. So, is that actually what I did? What I actually did was press a button, right? I pressed this button, and that sent a signal to somebody, in some system, that this building and this authority is associated with. Can you imagine all the contracts and agreements that are in place that enabled the lights to go on when I pushed that button? Right? All kinds of agencies and contracts and legal agreements that enabled the connection between me putting my finger on that screen and these lights coming on. Now, what I wanted to do, all I wanted to do, was put the lights on. And to do that, I just had to put my finger on a screen. And when we're talking about legal capacity and the right of people with significant disabilities to make their own decisions, what we're talking about is simply creating a system that enables my gesture to that puts my finger on a screen to make all those things happen. That's what we're talking about. To create a system that translates my will and preference to turn the lights on from touching this button to actually making the lights go on. I didn't make the lights go on all by myself. All I did was touch a screen. It took all kinds of others to enable that gesture to make that happen. And that's what we're talking about in supported decision making. So it's very simple. Because for some people with significant disabilities, that's what they can do. They can gesture. And if there's at least one other person that understands and can translate that gesture into a meaningful action, that's enough. And think of today. I'm speaking in English. I wish I was speaking in a language that most of you understood as your mother tongue. But we have translators, thank goodness, that enable us to have communication. The biggest problem for people with significant disabilities is that their translation systems aren't recognized in the law. And their translation systems, as in this case, is Rebecca's friend who she dances with and her network of people around her. All that we're seeking is to have that system of support recognized in the law as a legitimate translation mechanism for Rebecca to be translated as a full agent in the world, so that when she moves her finger or moves her head or smiles, she has people who can translate that into action. I happen to have gestures and ways of speaking and moving that are easily translatable in the communication systems we've got. For many people with significant disabilities, that's what they're lacking, and that's what we're looking at creating, which is really a new formula for the right to legal capacity. What we and in the new formula that the UN Convention provides, it starts with individual will and preferences. That's the first piece. You add to that my unique decision-making abilities, not the usual abilities that I have to understand and appreciate all the consequences and communicate those in ways that all of you will understand. I may have unique abilities, just like Rebecca. Her ability is to gesture in ways that at least a few others can understand. You add to that supports, and then the accommodations that doctors and banks and their need to provide, and their duties to engage with Rebecca as a full citizen, and a legal framework that recognizes her equal right to legal capacity. You put all of those together, and Rebecca will have the capacity to make her own decisions. So this is really the starting point, which is why I wanted to spend more time on it. Because if we don't pull all of this apart and start with those basic concepts, we may create some supports for people who can get a few additional supports for those people with disabilities who have mild or less significant disabilities to be able to participate, but we'll leave a whole group of people with more significant disabilities behind. And that's what inspired supported decision-making in the Canadian context was people with more significant intellectual disabilities who wouldn't have an opportunity to be recognized as having the right to decide. And I think that's our biggest challenge. And in talking with Christian and others here, I know that that's the biggest challenge, and we've got to find a framework that can recognize that. In this new formula, legal capacity is not equal to mental capacity. What a person wants, their hopes, their plans is at the center. The focus is on supports and accommodations. And this is really important. When people may have different ideas, for instance, about what Rebecca wants, usually our laws are organized to say, well, then let's act in her best interests, because nobody really knows. What the convention calls upon us to do is to create a process in which we arrive at the best interpretation of what her will and preferences are as a basis for making supporting people to make their own decisions. So it's moving from this old idea of best interests, that professionals can determine the best interests of a person with a disability, or a guardian can determine the best interests of a person with a disability, to the test being what's the best interpretation of a person's will and preferences, where there may be it may be indeterminate, or it may be difficult to understand what a person wants. So what this means is that we talk about basically 4 different ways to exercise legal capacity. So up here we have the state, which recognizes my right to legal capacity, and the UN recognizes it. And over here we have me wanting to make my way to, let's call this the community, where I want to make all these decisions. The usual way that people make their way to the community is what we might call independent decision-making. I meet that usual test of understanding and appreciating the consequences. And that the law really, that's who the law values in most cases. Those who can make decisions and make their way to the community all on their own. The problem is when you don't meet that test, you're assumed to be in need of guardianship. What we're trying to do is create a system where when you don't meet that test all on your own, we recognize that you need supports to make your decisions. That doesn't take away your legal capacity. What that recognizes is a group of people who can assist you to make your way to the community. The people who are going to translate my gestures, putting my finger on a screen, into a set of agreements and decisions. Also providing for, and the law does this now, what we'd call representative decision-making. So I know we use the same term in BC, but by that we mean powers of attorney. And you've got powers of attorney provisions in your legal framework in Austria. That's part of the legal system as well. If I empower Brendon to be my power of attorney if I have an accident or I develop certain cognitive disabilities, it may be a form of substitute decision-making, but I've decided that he's going to act for me. He's going to represent for me. So while it may be a form of substitute decision-making, I've decided it and put some parameters around it, and that's completely consistent with the right to legal capacity. And that's what we would call appointing a representative. In the framework we're developing in Canada, and again, this isn't all put into place, we have one category at the end, the kind of very last resort, which some might call guardianship, but I don't think it's guardianship. We call it facilitated decision-making. There are going to be situations, there are going to be Rebeccas of the world that have been in an institution all their lives, where they've lost contact with family, they've got no friends, and it's going to take a while until someone can understand her particular way of communicating. And because we don't know how to interpret her will and preferences yet, because she has a unique form of communication. So the challenge is, so in the framework that some of us are working on in the Canadian context, we call that facilitated decision-making. She needs to have access to people who are going to help facilitate decision-making for her to the best of their understanding and knowledge of what her will and preferences are. And as she gets around her network of people that get to know her better, she'll be able to be recognized to make her own decisions because we'll be able to understand her will and preferences. So this is a temporary last resort that recognizes we don't yet live in a world where everyone has around them friends and family who are committed to helping them make their own decisions. So basically, supported decision-making is having a group of others appointed to assist me in expressing my will and preferences and acting on those decisions. The system in British Columbia and that we're looking at in other parts of the country provide for appointing, me being able to appoint by myself who my supporters are going to be, or in cases like Rebecca, she would need to have her family or her network apply to be recognized as her decision-making supporters in order to provide a safeguard against abuse, against those who would simply apply to be someone's decision-making supporters and then end up abusing them financially or in other ways. So there needs to be a safeguard where there where people have more significant disabilities. And while we're building on, in other parts of Canada, we're building on the BC model, which doesn't really have this safeguard built into it, that where people have significant disabilities, basically their parents can, in effect, self-appoint themselves as the decision-making supporters, which we think, as we're working on this, is problematic. It's not enough safeguards to ensure that those who are supporters are in fact going to act and will act in the best interest or according to the will and preference of the person. So in some of the proposals we're developing, we're looking at how to review that application where a person has a much more significant disability. The types of support that need to be recognized in the law: decision-making supporters, peer support, communication assistance, plain language, alternate formats, independent advocates, the accommodation that is being recognized in case law, at least in the Canadian context. For example, more time by a doctor in the decision, giving Rebecca and her network more time in the decision-making process, a duty to provide plain language, so that the responsibility isn't always on me as the individual to understand the information on my own. The doctor, who I've come into the doctor's office with, also has a duty to communicate with me in a way that I can understand. So in this new approach to a legal framework that we're seeing in British Columbia and in other parts of the country, there's basically a presumption. We're moving from a legal framework where there's simply a presumption of capacity to the presumption to act independently. So everybody has legal capacity. The presumption is that I'll be able to make the decisions by myself. And if I can't, if I need support, then we recognize, as we do in BC and in other jurisdictions, the decision-making supporters. We move from capacity assessment, assessing my mental capacity, to assessing what my needs for support are, what we call in law in Canada the alternative course of action to a guardian. We move from detention in psychiatric facilities to the obligation to explore alternative support arrangements in the community. That's the obligation. We move from a finding of incapacity to a finding of need for support. We move from guardianship or substitute decision-making to supported decision-making, and we move from the best interest test to the test of the best interpretation of my will and preference. So I've been referencing Canada. I'm going to bring it to a close here. Basically, the law in different parts of the country recognize decision-making actors as the individual, the supporters of the individual, and imposes third parties on, or duties on third parties who interact with me as the individual decision maker, and obligations on the state. Those are the kind of four actors that we need to attend to in the legal framework that we create. I'm not going to go sort of across the country, but there are in some jurisdictions, as was noted at the beginning, the legal recognition of supported decision-making, contained in decision-making legislation, so a statute. I know we're in a common law country, you're in a civil code country, but some legal framework that authorizes this. Because we're in a federated country, our provinces have jurisdiction over civil and property rights, where I understand in Austria the jurisdiction is at the federal level. So it's different. You're in a better position to legislate in terms of the right to decide for the country as a whole. We've got to do it 13 times because we've got 13 jurisdictions. But in about half of our provinces, we now have a recognition of some form of supported decision-making. Really what that means is a planning document that provides for me to appoint 2 or 3 other people who are in my network to be recognized as the supporters in decision-making, or for them to apply to the court or to be appointed as my co-decision makers. It can provide for appointing a monitor if there's a concern about the safeguards or about having protections in place. And it provides for that planning document to talk about the kinds of things that are important to me, my will and preferences. So what we're working on introducing into different jurisdictions in Canada is simply the legal recognition that I can create these planning documents, but that I don't have to meet that test of mental capacity that I referred to at the beginning. That's the real challenge here. Because in Austria now, you can appoint powers of attorney, but you have to meet that mental capacity test. So what we've got to do is lower that threshold in order to empower people like Rebecca to appoint people to help represent and support her, or for people to apply to appoint or to be appointed as her supporters. That's what we need to do in the law, and then create the systems to assist people to develop their networks, to provide information, education, to assist people to make decisions. You've got in Austria resources. You've got guardianship agencies in the different jurisdictions. You don't call them provinces in Austria, but the second level of jurisdiction, as I understand it. The question is how to transform those roles. Because you've got, you've got, what, 55,000 people in guardianship, so you've got a number of publicly appointed guardians, also informally, guardians who are informal, as family members or friends. So it's about shifting their role and that they play. It's not doing away necessarily with all of those services. It's shifting their duty and responsibility. I'm going to bring it to an end. I think I've covered all of this pretty well. So the main lessons from the Canadian experience, and then Brendon's going to talk about Ontario and BC to some extent. How do we move from transforming this idea of supported decision-making, once we get into the law, into practice? Education and awareness is critical, not only for those who have traditionally been guardians, but for doctors and financial institutions, about their obligations to accommodate people. We need to account for the different ways in which people make decisions. Some independently, some with a support network, some by simply appointing their power of attorney. Really critical to include in the legislation the guiding principles and the obligation on the state or the government to ensure people have access to the supports that they need to exercise their right to decide. So that's an overview of the kind of the ideas and the concepts which have driven reform in the Canadian context and highlighting where some of those reforms have gone. Brendon's now going to share his experience as a lawyer in the Canadian context, trying to shift that system in the context of a system that's similar in many ways to what you've got in Austria right now, and ways in which we can push that system to be more inclusive, accommodating, recognizing, supported decision-making. So, and then we'll have time for questions and more discussion this afternoon. So over to you, Brendon, to pick this up. I'll come back. Sure. Okay.
Thank you, Michael. Next time I go first, you're a tough speaker to follow. Good morning, everybody, and thank you for welcoming me to your beautiful city. My wife and I have been here in Vienna for a couple of days now, and we've very much enjoyed your hospitality. As Michael mentioned, I'm a lawyer in the province of Ontario. I'm going to there may be some overlap between my material and Michael's material, but I'm going to come at it from a slightly different perspective, being a legal practitioner that works with individuals with disabilities and their families on a daily basis and trying to address all of these challenges that Michael has identified, as well as an adjudicator. I sit on a provincial sort of quasi-judicial board called the Consent Capacity Board that I'll speak about in a few minutes, that is responsible for making decisions regarding applications from individuals that have been detained in psychiatric facilities and individuals that have been found that have had a formal finding of incapacity when it comes to making decisions regarding either their personal care matters and or their property. Their property matters as well. So what I'm going to do is sort of, in terms of an outline, try to cover the law in Ontario a little bit, as well as BC, talk about the legal instruments that we have in place when it comes to planning for making decisions regarding personal care and property matters. I'll identify the issues and how we are trying as practitioners and adjudicators to respond to those issues, and we'll try to get through this material as quickly as possible so that you have an opportunity to ask us questions. As Michael mentioned, in Canada, we have 13 provincial and territorial jurisdictions. So that's our second level of government, and this second level of government is responsible for everything related to our property and civil rights. And so it's this second level of government that really governs our legislative frameworks when it comes to consent, capacity, and decision-making laws. So we generally hold up the province of British Columbia, which is all the way on our west coast, as sort of our Cadillac model in Canada. But as Michael mentioned, we do have other provinces that have engaged in some form of legislative reform. In Ontario, we have we've just started that within the last couple of years. But what I do want to highlight in Ontario, and the reason that I'm using Ontario as sort of our case study here, is that we already have some legislative protections in place to ensure that individuals with disabilities aren't automatically found incapable and don't have somebody appointed to make decisions on their behalf as a matter of a de facto solution. So that's something that I'm really going to try to highlight throughout the presentation this morning. In terms of the theme, when it comes to determining whether or not somebody has capacity, you'll hear me reference throughout the presentation this idea of the ability to understand and appreciate. So that's the ability to understand the information relevant to making a decision, as well as the ability to appreciate the consequences of that decision or lack thereof. So while there may be slightly different tests to determine whether or not somebody is quote-unquote capable, depending on what the nature of their decision-making relates to, this theme of the ability to understand and appreciate is prevalent throughout our legislation and our case law. So, we've got a slightly different test to determine whether or not somebody's capable of managing property, whether or not somebody is capable of making decisions related to their personal care. And when we talk about personal care, we're talking about healthcare, shelter, hygiene, nutrition, safety, and clothing. So all aspects of someone's personal care matters. There's a slightly different test to determine whether or not somebody is capable of granting a power of attorney for property decisions. There's another test to determine whether or not somebody is capable of granting a power of attorney for personal care. Whether or not somebody's capable of making a will or putting a will in place, and whether or not somebody is capable of entering into a contract. So there are all of these different tests. However, the theme for the ability to understand and appreciate is common throughout. Generally speaking, in Ontario, there are two broad areas of decision-making, one dealing with a person's property and the other dealing with personal care. And I've mentioned the different aspects of personal care. Regardless of both, there is this underlying presumption of capacity. So while we don't have any kind of sort of legally recognized supported decision-making model in place in Ontario, the law starts at a point where everybody is presumed to be capable. Okay? Unless evidence raises question of a person's capacity and a decision has to be made. So this is very important. I would say with probably about 99% of the individuals that with a disability that walk through our office, none of them, or 99% of them, have not been found formally incapable of making a decision with regards to their personal care or their property matters. And as a result, there is no legally appointed guardian or substitute decision maker in place. So it's a very important concept to sort of grasp. We start by presuming that everybody is capable, that everybody has legal capacity when it comes to their decision-making rights. Now, when it comes to determining who assesses capacity, it depends on what type of capacity is being evaluated and what type of decision needs to be made. When it comes to granting a will, making a last will and testament, or putting one of these powers of attorney in place, we've got two, one dealing with property, one dealing with personal care. It's typically the lawyer that's assessing whether or not the person is capable. So everybody that walks through our office, anybody that walks through our office, regardless of whether they have a disability, we have to ask a series of questions in order for us to be comfortable to move forward with taking instructions from them and preparing a document for them to sign. Okay? When it comes to healthcare treatment, so making decisions regarding medications and operations and anything related to healthcare, it's the doctor, it's the healthcare practitioner that is treating the individual that will determine whether or not he or she is capable of making that decision. In some cases, and I would say in the minority of cases, in very few cases, a formal capacity assessment is required. And if a formal capacity assessment is required, we have capacity assessors in Ontario that are regulated by the province, that are regulated by the government to carry out these assessments. These assessments typically only happen when dealing with powers of attorney. So if I've got a power of attorney in place, I may say in my power of attorney that I only want my attorney to take over and make decisions for me if I've been formally found to be incapable, and that's the role of a capacity assessor. Or if capacity assessment is otherwise required under the legislation. And this usually comes into play when a formal guardianship application is being made. So if a formal guardianship application is being made, if I'm applying to be somebody's guardian, the first thing that I have to do, the first step, is that I've got to go out and get a capacity assessment completed for the individual. And the individual has to agree to that assessment. If the individual doesn't agree to the assessment, it can't happen. Okay? In terms of the capacity to consent to personal care decisions, and remember I said the law is slightly different when it comes to personal care and property. The legal threshold that Michael was referencing in his presentation is much lower when it comes to making decisions regarding someone's personal care as compared to decisions that relate to property. So the requirements are that somebody has to be able to understand the information relevant to making a decision and appreciate the consequences of that decision. When trying to determine whether or not somebody meets that legal threshold, what I've done here is I've identified a few questions that a capacity assessor may ask. So can the person understand the condition for which the specific treatment is being proposed? Can the person understand the information relevant to making the decision? And is the person aware of the risks and benefits associated with that decision? So let's say we're dealing with an individual that requires psychiatric treatment. Okay, does the person understand the information relevant to his or her condition and the information relevant to the decisions? Generally, from a general standpoint, that's part one of the test. Part two of the test then touches on whether or not the individual is able to apply that information to himself or to herself. Okay, can they understand the risks and the benefits of taking this medication as it relates to that person personally? In terms of the capacity to manage property, we'll see that the requirements are kind of a lot higher. Again, we have this theme of the ability to understand and appreciate, but when it comes to the questions, when it comes to really determining whether or not somebody is able to understand and appreciate, the questions are a lot more difficult. Okay? Is the person aware of the nature of his assets, liabilities, income, expenses, and responsibilities towards dependents? So again, when somebody comes in to meet with us and we're trying to assess whether or not under the law they would be deemed to be capable of managing property, we have to ask a series of questions around what somebody owns. What is the nature of their income? Does somebody understand the difference between $100 and $10 when making a purchase? Does the person experience difficulties with orientation, memory, or calculations that affect financial management? And because a lot of our practice is really geared towards individuals with intellectual and developmental disabilities, this sometimes poses a challenge. Does the person have an appreciation of his or her strengths or weaknesses? And is there a demonstrated ability to make reasonable decisions? Is the person expected to be able to make these decisions in the foreseeable future? So again, the reason that I've identified these questions is just to give you an idea as to the legal threshold, how high the bar has been set when it comes to determining whether or not somebody has the legal capacity to make decisions regarding to their property and their finances. If somebody is unable to make those decisions on the property side of things, we have in Ontario, we have a hierarchy of substitute decision makers. Okay? At the top of that hierarchy, we've got a guardian. And the only way that somebody can have a guardian in place in Ontario is that guardian is appointed by the courts or by the government, something called the Public Guardian and Trustees Office. That's an arm of the government. Second on that list is an attorney for property. So if somebody is capable of granting another person with the authority to make decisions regarding their property, through this power of attorney document, that person would then be legally authorized to make decisions on their behalf. And if there is no guardian or power of attorney in place, then the government steps in. The Office of the Public Guardian and Trustee steps in to act as a guardian for the individual. Okay, but keep in mind, as I mentioned earlier in the presentation, this happens in very, very, very few cases. Even though if somebody were to go through a capacity assessment to determine whether or not they're able to make decisions regarding their property, even though the person may fail that assessment and be found incapable, very, very rarely is a guardian appointed. Okay, we try to source other means of helping that person make the decision, address the decision that needs to be made, even though the supporters may not be legally authorized before the law. We try to be creative, we try to raise the bar, and we try to put a process, a mechanism in place to ensure that guardianship isn't required. On the personal care side of things, so when we're dealing with healthcare, when we're dealing with shelter, when we're dealing with hygiene, safety, nutrition, etc., there is a much sort of broader hierarchy of substitute decision makers. We have our guardian, we have our attorney for personal care. We then have somebody that can be appointed by the Consent and Capacity Board, and I'll talk about that in a few minutes. But then we have de facto substitute decision makers that are comprised of family members. So in other words, if I am in an accident and I'm in the hospital and I require an operation, and the doctor doesn't think that I'm able to make a decision because I'm not going to be able to understand the information, I'm not going to be able to appreciate the nature of my decision. The doctor should probe to determine whether or not I have a guardian. In most cases, people won't have a guardian. Then they will ask whether or not I've executed a power of attorney. If the answer is yes, then that attorney makes decisions for me. If the answer is no, then we go down the list to somebody appointed by the Consent and Capacity Board. Almost nobody has a representative appointed by the CCB. And then we get into family members. So if I don't have this power of attorney document, if I don't have a guardian, then my spouse, my wife, is next on the list to make that decision for me. There is no formal appointment process that is required. The law just simply says if I can't make the decision, then my spouse can make that decision for me. Michael had touched a bit on ensuring that there are protections in place in our legislative frameworks to guard against responding to abuse. In Ontario, there are sort of two main means of addressing abuse. One is to go to the police. So if I'm aware of an individual that may be lacking capacity to make decisions, especially with regards to their property matters, I would go to the police. The police may or may not decide to investigate and initiate a fraud investigation. I've referenced this arm of government called our Public Guardian and Trustees Office. That office also has an investigations unit. And that investigations unit is charged with following up on complaints made around somebody potentially suffering abuse of another individual due to the likelihood of incapacity. So there doesn't need to be a formal finding of incapacity, but if I think that somebody's capacity may be in question, and I think that there is some, let's say, abuse with regards to their finances that is taking place, I can call the Public Guardian and Trustees Investigations Unit and report it, and they're obligated to follow up and investigate the matter. In terms of legal instruments that we have in Ontario, and I've referenced the power of attorney documents quite a bit, but once again, we've got one dealing with our property and we've got one dealing with our personal care. With respect to property, a couple of points on that. You've got to be at least 18 years old to execute one of these, and whoever you name has to be 18 as well. I view the continuing power of attorney document as a quasi supported decision-making document, and here's why. I don't have to be found incapable in order for the person that I name to act. So in other words, I can execute this document today and sign it, authorizing my spouse as my attorney, and she's able to act right away. So I can choose to put a supporter in place right away that is legally recognized before the law. Okay, I don't have to be found formally incapable before her decision-making rights commence. The issue, and Michael touched on this quite a bit, the issue with implementing a continuing power of attorney for property is that our legal threshold for determining whether or not someone can grant one is very, very high. And here, this is actually taken right from the legislation. These are the requirements. So the person has to know the kind and value of their property, must be aware of their obligations to dependents, to spouse, to children, etc., must know the authority of the attorney. So know that they're granting this authority to somebody else, and understand the fact that this person can now pay their bills, sell their house, do anything that they can do with matters related to their property. Know that the attorney must account for all of their actions. Know that they have the ability to revoke that authority that they've granted. Know that the value of their assets may actually depreciate by giving the authority to somebody else, and appreciate the fact that the attorney may misuse their authority. So you see the challenge for us as a practitioner when somebody comes into our office to execute one of these documents. We have to ensure that they meet all of these different requirements in order to move forward with putting one of these continuing powers of attorney in place. And towards the end of the presentation, I'll talk a little bit about the sort of alternative to a continuing power of attorney for property in BC, and how BC kind of gets around these requirements. A power of attorney for personal care authorizes somebody to act on an individual's behalf with regards to all of those personal care matters that I've identified. In Ontario, somebody is presumed capable of making all decisions relating to their personal care at age 16. So at age 16, I'm going to determine where I'm going to live, whether or not I'm going to accept medical treatment, what I'm going to wear, what I'm going to eat. All of these decisions all of this authority is granted at age 16. So at age 16, I'm able to actually designate somebody else to make those decisions for me if I'm unable to do so myself. And that's what a continuing power of attorney is. In order to put one of these in place, the legal threshold is very, very low. So we're actually able to put a lot of continuing powers of attorney in place for individuals with a developmental disability or an intellectual disability, because all that is required is the ability to understand that the attorney has a genuine concern for the person's welfare and appreciates that the attorney may have to make decisions for that person. So do I know that the person that I'm identifying cares about me? And do I understand the fact that they may have to make a decision for me at some point in my life? That's all that it takes. And so as a practitioner, I wouldn't say in all cases, but in the majority of cases, we feel comfortable enough that the person is able to meet this legal test, and we're able to move forward with putting the power of attorney for personal care in place, regardless of the any kind of communication challenges that we may face. We really do strive to ensure that plain language materials are available, that translation services are available, whatever it takes for us to elicit the information required that provides us with a comfort level that the person understands and appreciates. And then court-appointed and statutory guardianship. So as I mentioned earlier, or as I've been trying to mention earlier, guardianship is our absolute sort of last resort in Ontario. And it is, for the most part, very, very uncommon. Even though somebody may not meet those legal thresholds of understanding and appreciating, we sort of try to rally around that individual with an informal support network to help them to get to that decision. Sometimes it works, sometimes it doesn't. Sometimes the banks listen to us, sometimes the healthcare practitioner listens to the individual with supports. Oftentimes they don't. It's not legally recognized in our law as of yet. However, there are quite a few informal support mechanisms in place. When it comes to personal care matters and guardianship, only the court can appoint a guardian. Okay, so the first step is whether or not the person has been found incapable by a capacity assessor. The second step is the judge agreeing with the applicant to the guardianship application in terms of the person requiring somebody to step in and make decisions for them. When it comes to our property, a guardian for property is either appointed by the court, or there's a process through the public guardian and trustee's office, through our designated government office, whereby somebody can apply to become a person's guardian. When I started off this presentation, I identified the fact that even though we have a substitute decision sort of framework in place in Ontario, we do have a few protections. I started off by saying, there is this presumption of capacity, which is very important. But the second one, when it comes to guardianship, is that the courts must consider what we call our less restrictive provision. Here's what the less restrictive provision says. The court shall not appoint a guardian if it is satisfied that the need for decisions to be made will be met by an alternative course of action that A, does not require the court to find the person to be incapable of property or personal care, and B, is less restrictive of the person's decision-making rights than the appointment of a guardian. So in other words, it's the judge's responsibility or counsel's responsibility if they're opposing the guardianship application to make sure that the applicant is probed, to make sure that they are satisfied that there is no other way for supporting this person in terms of making decisions regarding to their personal care or their property matters before a guardianship application or guardianship order is put in place. Okay, this reinforces the fact that guardianship is the absolute last resort when it comes to appointing a decision maker. Unfortunately, we don't see, and I guess I'll get into this in a few minutes with some of our issues, but even though that provision has been law since 1992, I believe, we very rarely see it show up in our judicial decisions. We very rarely see that the necessary probing take place by the judiciary. What's also unique about Ontario in terms of legislative protections is that we've got a as I mentioned earlier, a quasi-judicial body called the Consent and Capacity Board in place. This board has been created in law by our Mental Health Act and by our Healthcare Consent Act. It's comprised of lawyers, psychiatrists, and public members that sit in panels to determine or to review applications that are made by individuals that have been detained in our psychiatric facilities and applications that are made by individuals that have been found to be incapable of making decisions regarding personal care matters and or property matters. And what's unique about this legislation is that when somebody is found incapable, if they're in one of our psychiatric facilities, they are entitled, they have a legislative right, they have a legal right to what's called rights advice. So immediately after being found incapable, a rights advisor sees this individual and explains to them what it means to be found incapable and provides them with the paperwork and the application to appeal. So once the appeal has been launched, the Consent and Capacity Board must hear the appeal within 7 days. Okay? After hearing the appeal, we have to issue our decision within 1 day. And if either party requests reasons for our decision, we've got to turn those around in 4 days. So it's a very, very quick process. It's a very, very expedient process to ensure that the person's appeal rights have been exercised in a timely manner when it comes to their finding of incapacity. Okay. So our issues. in Ontario, as a sort of an advocate for law reform in this area, we do, even though we do have some protections in place, we still have this overarching framework of a substitute decision-making model, and we're trying to. Time? Okay. So I'm gonna sort of wrap things up here. We have a substitute decision-making model. Our legislative requirements for putting powers of attorney in place are very, very high. In order for a guardian to be appointed, or in order for any kind of person to be appointed to support the individual through their decision-making process, that individual has to be stripped of all their rights, all of their decision-making rights, and those rights are given to somebody else. Even though we have this less restrictive provision in place in our law, when guardianship applications are made, it's very rarely exercised. What do we do as an adjudicator? We respect the individual's rights to a fair hearing. We ensure that we exercise, that we respect the person's legal rights. Canada is one of only 4 countries that has a constitutional protection in place for people with mental and physical disabilities. We have human rights codes in place that are quasi-constitutional as well, that have this concept of the duty to accommodate. What this means is that we've got to go above and beyond to ensure that the person is accommodated with respect to plain language materials, interpretation, mobility devices, etc., to ensure that they have the right to a fair hearing and that they are being heard. We have to ensure that we are making decisions that do not contemplate best interests, and Michael really spoke quite a bit about this. We are not the person's when you're determining or evaluating, assessing a person's capacity. You're not looking at their best interests. You're not trying to determine whether or not a decision is a good one or a bad one. You're really only focusing on this idea of understanding and appreciating. As a legal practitioner, the tensions that we face, family members of individuals with developmental disabilities are confused and searching for a solution because they're hearing from their schools and their governments and their doctors and their banks that they've got to go out and get guardianship, and that guardianship is the only way. The reason being that it's such a complex area of law and that people really don't understand the intricacies there. So as a practitioner, we generally discourage people from pursuing guardianship unless it's absolutely we need it, and we try to counsel them on ways of other legally recognized solutions. We encourage the granting of a power of attorney if a person is able to do so. We stress the fact that accommodation is consistent with a person's legal rights. We use trusts, and I won't get into this too much to decrease the possibility of guardianship. We offer a lot of training, and Michael really touched on this, education and awareness. We offer a lot of training to various stakeholders in all aspects of governments and banks and in the medical profession as well. And we really do promote the development of personal support networks with the hope that these personal support networks will eventually become legally recognized in our legislation one day. Thank you.